I think one county did it along this way, that's nigger. Cop people, I think, do a bit longer. I think.
So there are only going to be a few of them in your school here?
I think we did this long without them. Since the school opened, I think we do a bit along without them.
How do you boys feel about it?
We don't want nigger. No nigger.
No niggers.
We don't want them.
No. They don't want to come to school, they just want to come and cause trouble.
Brown v. Board was one of many cases involving the segregation of public schools. Oliver Brown's daughter, Linda, a third grader, was forced to walk extra miles to a black school instead of attending a white school closer to her home in Topeka, Kansas. Her father, Oliver Brown, took the case to court where they lost at the state level. With the help of the NAACP, a group of 13 parents enrolled their children into a white school. When they were denied, they reported back to the NAACP. They appealed to the Supreme Court on October 1, 1951. The Board of Education argued that other black scholars didn't see it as an issue to go to an all-black schools. The Brown case said that it was unconstitutional because they were protected under the 14th Amendment. The court ruled that the segregation of schools was unconstitutional. The case lasted 4 years. The government didn't enforce the law right away, but instead the Chief Justices of each state together came up with a plan. It would take years before the plan became efficient, but it was a large step in equal rights for all citizens. 9 African-American boys were accused of raping 2 girls, Ruby Bates and Victoria Price, after boarding a freight train headed through Alabama. They were tried in the state Supreme Court where only one attorney agreed to defend the boys the day of the trial. Consequently, they were found guilty on the state level and 8 of the 9 boys were sentenced to death. They appealed their case to the Supreme Court, saying that the court violated their right in the 6th Amendment because they didn't have an adequate amount of time to prepare a case with their counsel. The court had to answer if the state would provide the counsel, if the person could be sentenced to death without a counsel, and if it was guaranteed in the 14th Amendment.
In this country, our courts are the great levelers. In our courts, all men are created equal. I'm no idealist to believe firmly in the integrity of our courts and of our jury system. That's no ideal to me. That is a living, working reality.
Justice George Sutherland reversed their convictions under the Due Process Clause. They ruled that counsel must be provided to anyone possibly facing death charges and found that it was a fundamental principle of liberty. The ruling led to a more in-depth interpretation of the 6th and 14th Amendments. More people got fair trials because now everyone was provided a counsel by the state, when before it was only for those who could afford a counsel. Charles Schenck was the General Secretary of the Socialist Party of America. They believed that World War I was both caused by and benefited the rich. In 1919, Schenck sent out over 15,000 leaflets that encouraged Americans to oppose the war draft. He was arrested for violating the Espionage Act of 1917, which established that anyone who attempted to get an individual to oppose the war draft was fined $10,000 or 20 years in prison. The case was appealed to the Supreme Court in 1919. Schenck's argument was that he had the right to the freedom of speech granted to him in the First Amendment. The Supreme Court stated that they had the right to ensure the U.S.'s defense, and it was a danger to the nation to deprive the U.S. of necessary soldiers. In 1919, the U.S. found Charles Schenck guilty on a 9-0 vote. Justice Oliver Holmes stated it was the way something was said, and if found to be harmful, was not protected under the First Amendment. Justice Holmes expressed his views in what is today called the clear and present danger test, a test that has been used for many years after this case. This test essentially means that any time the government claims someone's speech imposes any danger, the judges consider the seriousness of the danger and the likelihood of it occurring. An example is if an individual makes a speech involving dictatorship and overthrowing the government, they can't be punished unless that danger is actually likely. Benjamin Gitlow was an individual considered to be a socialist and anarchist of the U.S. government. Gitlow was charged with passing out magazines and leaflets named the Left Wing Manifesto that promoted anti-government views and degraded the federal government. The U.S. was afraid that the pamphlets would cause a government uproar. He was also convicted of violating the New York Criminal
Anarchy Law of 1902, which discussed any crime of violent overthrow of the government. Gitlow was convicted in New York but appealed to the Supreme Court. Gitlow argued that the state of New York violated his constitutional rights in the First and 14th Amendments. The 14th Amendment states that no state could deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction equal protection of laws. The Supreme Court had to answer if the New York law violated Gitlow's freedom of speech in the First Amendment. The U.S. Supreme Court found him guilty of his crimes, but they also found New York had abused their power given to them in the Constitution. The 14th Amendment was not considered a part of the Bill of Rights, so it was believed that protection of those rights were given to the state. The Supreme Court ruled the First Amendment applied to states also because of the Due Process Clause. Therefore, the Bill of Rights now applied to states as well. The Supreme Court's rulings of the Bill of Rights are now in effect on both federal and state levels. Although the speech of Gitlow had little effect, the state still may punish those endangering or threatening the government. The Supreme Court made the statement that freedom of speech and press were now fundamental rights and was protected under the Due Process Clause of the 14th